Hello and welcome. I will be reading both the ACLU Amicus brief pertaining to the Karen Reed case, and I will be reading the Commonwealth's brief. Both court filings were filed yesterday, October 16, 2024, and this is the definition of an amicus brief according to Cambridge University, for those who would like to know. And again, the ACLU filed an amicus brief, and according to this definition, an amicus brief is a legal document submitted to a court by a person or organization not directly involved in a case, providing advice or information related to the case. It is often used to offer additional insights or perspectives that may influence the court's decision-making process. So let's read the amicus brief from ACLU. So before I read the ACLU amicus brief, I just want to provide a brief description of what the ACLU is for those who don't know. This is directly from the ACLU website. It reads, "The ACLU today. For nearly 100 years, the ACLU has been our nation's guardian of liberty, working in courts, legislatures, and communities to defend and preserve the individual rights and liberties that the Constitution and the laws of the United States guarantee everyone in this country. Whether it's achieving full equality for LGBT people, establishing new privacy protections for our digital age of widespread government surveillance, ending mass incarceration, or preserving the right to vote or the right to have an abortion, the ACLU takes up the toughest civil liberties cases and issues to defend all people from government abuse and overreach." All right, that's the ACLU. Let's read their amicus brief. So one reason I wanted to read the ACLU amicus brief is because they had actually filed it hours before the Commonwealth filed their brief. So this filing is dated 10/16/2024 at 11:30 a.m. And this is the one that the ACLU provided to the Supreme Judicial Court. And the brief that the Commonwealth filed was in the afternoon. I believe it was after 4 o'clock in the afternoon. And that's interesting too, that the that the Commonwealth had the deadline to file their response, and the ACLU actually beat them to that deadline. It's just funny to me. Not surprising either. Anyway, here's the document. It reads, Commonwealth of Massachusetts Supreme Judicial Court, Plaintiff Appellee versus Karen Reed, Defendant Appellant, an appeal from reservation and report of GLC 211, subsection 3, petition. Supreme Judicial Court, Single Justice Dewar, provides the case number, brief of Amicus Curiae or Curiae. I've heard it pronounced differently, but I believe it's Curiae. And it's just plural. It means friend of the court. So the ACLU is not like an intervener in this brief. They're just acting as a party to assist the court in their decision. So the ACLU doesn't actually have a role in this case. They won't be permitted to have a role in this case unless the Supreme Judicial Court grants them a role in this case. Right now, the ACLU is just saying, hey, here are our lawyers. These are our council members. We've cited case law, and we feel you should look at this before making your decision, which is really good for Karen Reed. It provides the attorney's table of contents, table of authorities, and continuing with more table of authorities. Constitution, statutes and rules, other authorities. All right. And this is a corporate disclosure and Rule 17C5 statement. Pursuant to Supreme Judicial Court Rule 121, the American Civil Liberties Union of Massachusetts Incorporated, ACLUM, is a nonprofit corporation organized under the laws of Massachusetts. ACLUM does not issue any stock or have any parent corporation, and no publicly held corporation owns stock in ACLUM. No party or parties counsel authored the brief in whole or in part. No party, parties counsel, or any other person or entity other than ACLUM, its members, or its counsel contributed money that was intended to fund the preparation or submission of the brief. ACLUM and its counsel do not represent and have not represented one of the parties to the present appeal in another proceeding involving similar issues, and were not parties in and did not represent a party in a proceeding of legal transaction that is at issue in the present appeal. So it's essentially a statement saying nobody from either side, either party in this appeal, whether it's the Karen Reed defense team or the Massachusetts Commonwealth, the prosecution, neither side provided any money or any agreement with the ACLUM. The ACLUM filed this brief completely and entirely on their own, and there is no father or parent corporation for the ACLUM. They are their own corporation in and of themselves. They are doing this entirely independent from either the prosecution or the defense team, which again gives it more credit when you think about it. Just like when we think about the ARCA experts, the two doctors who testified on the stand during trial, neither the prosecution nor the defense team paid for their testimony or paid them to conduct the experiments that they conducted. Therefore, their experiments and their testimony was more credible. They don't have, they don't have any like financial gain coming from this, and, unlike the prosecution, unlike the Norfolk District Attorney's Office, just there's a lot of shady shit going on over there. But thankfully, ARCA and the ACLU have both provided independent statements pertaining to this case without any help from the defense or the prosecution. Okay, guys, this is a big deal. I'm trying to stress that. Like, this is a big fucking deal. It's an independent party coming in with a group of lawyers, not Karen Reed's lawyers, but an entirely different group of lawyers saying, hey, we looked at this case, we looked at these court filings, and we didn't like what we saw. And we want you guys to look at what we have to say as lawyers before you make your decision. It's a really good news and a really big deal. Interests of Amicus Curiae, ACLUM is the Massachusetts affiliate of the National American Civil Liberties Union. ACLUM is dedicated to protecting and advancing the civil rights and civil liberties of all people in the Commonwealth, including those guaranteed by the Constitution and the Bill of Rights. ACLUM frequently engages in litigation and other advocacy to protect the rights of people involved in the criminal legal system. As part of that work, ACLUM has filed many amicus briefs before the Supreme Judicial Court, and they list all, well, not all, but they list a number of amicus briefs they filed within Massachusetts via the same Supreme Judicial Court that Karen Reed filed her motion. So what they're saying is, we've got experience here. This isn't our first rodeo. This is not our first amicus curiae, our amicus brief. Yeah. It's good stuff. Okay. Continuing to read. Here, ACLUM takes no position on what the evidence presented at trial did or did not show. Rather, this brief addresses the trial court's decision not to respond to compelling evidence that there was a potential mistake or misunderstanding concerning the outcome of the jury's deliberations, and what processes will be employed by trial courts addressing any similar circumstances in the future. All right, so right here they're saying they're not staking a position on what the evidence was or was not. They're sticking to the court's decision to not respond to the evidence, the compelling evidence. They're focusing on what Judge Beverly Cannoni did, as opposed to what evidence was shown during trial. They're focusing on what she did and the evidence of what resulted, the accumulative evidence of what resulted. So yeah, right here, the outcome of the jury's deliberations. So this will not pertain to anything during the trial. It will pertain to strictly what the jury members, what was concluded from their deliberations and what Judge Beverly Cannoni did with that information. Okay, introduction and summary of argument. Defendant appellant Karen Reed faces the possibility of being retried on multiple criminal charges for which numerous jurors now claim they acquitted her. A retrial on acquitted charges would violate the prohibition against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and Massachusetts common law. If the court does not grant appellant's requested relief to dismiss or otherwise preclude the counts on the current record, then this court can and should prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing and determine whether the jury in her first trial agreed to acquit her on any count, such that it was not manifest necessary. Okay, let me read that again. Such that it was not manifestly necessary for the trial court to declare a full mistrial. This brief provides the court with additional context regarding the justification for evidentiary hearing into a lack of manifest necessity. So far, they're asking the Supreme Court, to prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing. They're asking the Supreme Judicial Court to conduct an evidentiary hearing. And again, that's really good news, because not only is the Karen Reed defense team asking for an evidentiary hearing in their most recent court filing. Remember, they had 3 requests, and one of those requests was an evidentiary hearing to determine what those verdicts were. And so too is the ACLUM. They too are asking the Supreme Court to order an evidentiary hearing. Really good news. Continuing to read. At appellant's first trial, the court declared a mistrial on all 3 counts after receiving notes indicating jurors were struggling to reach a unanimous verdict, but the court did so without polling jurors to confirm they were deadlocked on all counts. and in parentheses, or even asking the parties whether they consented to a mistrial or wanted the jurors polled. And that's the end of parentheses. Yes. So you see, these lawyers were paying attention too. They were paying attention toward the very end of trial. What happened leading up to the mistrial? You see, and it's as if Judge Beverly Cannoni didn't care that this was going to happen. It's as if she didn't care that other lawyers were going to be watching the trial and they were going to see her corruption. She didn't care, right? She didn't care. But you know, you reap what you sow, people. You reap what you sow. Not only did the Karen Reed defense team try to tell Beverly Cannoni that she was wrong, here is another independent, entirely separate group of lawyers telling Judge Beverly Cannoni that she was wrong. She did not even poll the jury, and she did not ask the prosecution or the defense team what they wanted to do, if they consented to the mistrial. Really good on the ACLUM. All right, continuing to read. Soon after that hasty mistrial declaration, guys, oh, that's so great. That's so wonderful. It's so, I can't find a word. It's so validating. It is so validating. Soon after that hasty mistrial, they are holding Judge Beverly Cannoni accountable by referring to it as a hasty mistrial. She rushed it. Continuing, multiple jurors reported that the jury had actually agreed to acquit appellant on counts 1 and 3, and so were only deadlocked on count 2. And that's the truth. If you've been following this court case up until this point, that is the truth. It's the total truth up until this point. Continuing, appellant promptly moved the trial court to either dismiss counts 1 and 3 at minimum conduct a post-verdict evidentiary hearing to assess the truth of the jurors' reports. But the trial court, aka Judge Beverly Cannoni, denied the motion to dismiss and refused to conduct a hearing, leaving open the possibility of appellant being retried in violation of her right to be free from double jeopardy. 1,000%. 1,000%. And remember, guys, remember, Judge Beverly Cannoni herself in her own court filing said that the jury statements that Karen Reed was essentially acquitted of counts 1 and 3, unanimous not guilty verdicts on count 1 and 3, Judge Beverly Cannoni considered those verdicts true and accurate. True and accurate. As in, actually, Karen Reed was acquitted on counts 1 and 3. Judge Beverly Cannoni herself agrees. But she did nothing with that information. She obfuscated the argument along with the Commonwealth, along with the prosecution. And what did they say? It's like, everybody, let's all say it together. We can't go into the jury deliberations, right? All right. But here's the ACLUM. Here's the ACLUM telling Judge Beverly Cannoni and the prosecution, you guys fucked up. Continuing, the trial court erred in refusing to conduct an evidentiary hearing. Yes, right here. They are saying the Judge Beverly Cannoni erred. She incorrectly refused to conduct an evidentiary hearing. Continuing, the double jeopardy clause protects a defendant's fundamental right against successive prosecutions for the same offense. That right is deeply rooted in our nation's history and legal system and has been vigorously enforced by both the United States Supreme Court and this court. To avoid improper successive prosecutions, the double jeopardy clause requires that courts carefully consider alternatives to declaring a mistrial, and to make such a declaration only after finding a mistrial to be a manifest necessity. A failure to do so can bar re-prosecution on double jeopardy grounds. Right here. they're providing a legal argument that it was supposed to be carefully considered. There were supposed to be alternatives to declaring a mistrial. She wasn't supposed to rush to a mistrial. And because she rushed to a mistrial and there was no necessary reason, there was no manifest necessity, it was actually not necessary for her to declare a mistrial. Her failure to declare a mistrial should bar Karen Reed from being re-prosecuted. And again, these are the same arguments that the defense team has already made. But this is an entirely different group of attorneys from the ACLUM making the same arguments. And guys, it is validating. Continuing to read. The trial court had a clear path to avoid an erroneous mistrial. Simply ask the jurors to confirm whether a verdict had been reached on any count. That's simple. That's simple. The court had a clear path to avoid an erroneous mistrial. Simply ask the jurors to confirm whether a verdict had been reached on any count. And again, if Judge Beverly Cannoni was following, let's all say it together, Rule 27B, she would have known that she was supposed to ask the jury if there were any verdicts that they did agree on before she declared a mistrial. Continuing to read. Asking those questions before declaring a mistrial is permitted, even encouraged by Massachusetts rules. Yes. All right. Again, guys, I always leave the links in the description below if you don't want to hear me, okay? You're going to hear me in all my reactions because that's what I do. I read the documents. I provide my reactions, my commentary. This is such good news. And if you think I'm annoying, if you're annoyed by me, please just jump down to the description below to read the document yourself. All right. All right. Continuing. Such polling serves to ensure a jury's views are accurately conveyed to the court, the parties, and the community, and that defendants' related trial rights are secure. Yes. See, you're supposed to be extra fucking careful before you declare a mistrial. You're supposed to make sure you dotted your I's and crossed your T's and, and you followed the fucking rules of criminal procedure. Continuing to read. It is also consistent with a nationwide practice of polling juries to ascertain verdicts. Do you see this, guys? They have to put it in black and white for Judge Beverly Cannoni. They have to put it in black and white for her. And yes, this is for the appellate court. This is for the Supreme Judicial Court in Suffolk County. However, you know damn well that Judge Beverly Cannoni is reading this. She has to be reading this. Or could she be that arrogant that she's not even going to bother? But they're putting it in black and white. It is a nationwide practice to poll the juries. It's that simple. Everybody does it in this country. Why didn't she poll them? Continuing to read. Okay, don't want to lose myself. Okay. To ascertain verdicts, including before declaration of a mistrial. Here, a post-trial evidentiary hearing would serve the same purposes, enabling the trial court to determine whether the jurors had actually agreed to acquit appellant on counts 1 and or 3, such that it was not manifestly necessary for the court to declare a full mistrial. So right here, they're saying that before she declared a mistrial, she should have polled the jury, and that a post-trial evidentiary hearing is only going to be the same thing. It's only going to be polling the jury, but after the trial, post-trial. So they're not asking for anything extraordinary. They are just asking for what she should have done before she declared a mistrial. It's brilliant. Well worded. Good job. Continuing. Sorry. Okay. Accordingly, an evidentiary hearing is required to safeguard appellant's rights under the Double Jeopardy Clause, and the court should order the trial court to conduct one. Yep. They're continuing to ask the Supreme Judicial Court to hold an evidentiary hearing. And again, as I said before, I hope the Supreme Judicial Court is watching. I hope they know that the world is watching. All of us are watching what they do here. We now have two separate, completely, entirely independent groups of lawyers. The Karen Reed team, her group of lawyers, and the ACLUM group of lawyers. Two different groups of lawyers asking the Supreme Judicial Court to conduct a post-trial evidentiary hearing. And again, the world is watching. The world is watching the Supreme Judicial Court and what they're going to do now that two separate groups of attorneys have asked them to do the exact same thing. It continues. Number 1, the prohibition against double jeopardy is a fundamental constitutional right that protects against the burden of multiple prosecutions. The Double Jeopardy Clause of the Fifth Amendment provides that no person shall, quote, be subject for the same offense to be twice put in jeopardy of life or limb, end quote. U.S. Constitution amended v. quote, at the heart of this policy is the concern that permitting the sovereign freely to subject a citizen to a second trial for the same offense would arm government with a potent instrument of oppression, end quote. So far, the ACLUM has cited the exact same case law that the Karen Reed defense team cited. Continuing, thus the Double Jeopardy Clause exists to ensure that the government, quote, with all its resources and power, end quote, is not allowed to, quote, to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity, end quote. Again, they are citing the same case laws that the Karen Reed defense team cited. Continuing, the historical roots of the Double Jeopardy Clause long predate the American founding. Quote, its origins can be traced to Greek and Roman times, and it became established in the common law of England long before this nation's independence, end quote, and provides the case law. Quote, fear and abhorrence of government power to try people twice for the same conduct is one of the oldest ideas found in Western civilization, end quote. In medieval times, medieval times, guys. Ooh, they went way back. In medieval times, canon law prohibited double jeopardy on the basis that, quote, God does not punish twice for the same transgression, end quote. And it provides an authority history of double jeopardy. Continuing, and, quote, as early as the 15th century, the English courts had begun to use the term jeopardy in connection with the principle against multiple trials, end quote, provides the case law. This thread continued through Sir Edward Coke's 17th century treatise on the laws of England, which articulated a theory of double jeopardy. Provides the case law. No, it provides a citation. Continuing, Institutes on the Law of... rereading it. Okay. Institutes on the Law of England, 212 to 213. That was a citation. Yeah, I just reread the whole thing. Okay, continuing, guys. Sorry about that. It was citing the attachment they provided with this filing. Okay, and in his 1769 commentaries, Sir William Blackstone famously wrote of the, quote, universal maxim that no man is to be brought into jeopardy of his life more than once for the same offense, end quote, provides the citation. Continuing, concerns about double jeopardy crossed the Atlantic with early American colonialists. In fact, the, quote, American conceptualization of double jeopardy began with the Massachusetts colony. Yeah, that's so, you know what, pulling away, that's synchronistic, because I was like having a discussion with someone the other day about it all began in Massachusetts, you know. So much crazy shit on this continent in the U.S. You know, it's spread from Massachusetts. Again, the state I live in. There's so much history here. Some of the oldest houses are still in Massachusetts, and you know, the land, so-called land trading and what have you, pilgrims. Just so much, guys, there was so much corruption from the very birth of this country, and it all started in Massachusetts. A lot of it started in Massachusetts. But anyway, continuing to read. The 1641 Body of Liberties provided for an expansive prohibition against double jeopardy that extended to criminal and civil offenses. Provides a citation. Continuing. The provision was mirrored and extended in the Massachusetts Code of 1648, which required the express recording of past legal actions to prevent future jeopardy. Wow. Okay. So they are cementing, the ACLUM is cementing that actually for centuries, there is case law upon case law why we don't take these things lightly. We take them very seriously. Okay, continuing. These foundational tenets of Massachusetts law arguably shaped the nation's subsequent adoption of the Double Jeopardy Clause in the Fifth Amendment. Yeah. It's like the ACLUM is saying, you know, Massachusetts is the birthplace of this shit. And yet, look at what Massachusetts is doing. Look at what a superior court in the state of Massachusetts is doing, despite the origins of the Double Jeopardy Clause in this country. Oh, okay, continuing. While enactment of the Double Jeopardy Clause was relatively uneventful, provides a citation, early American jurists quickly recognized its importance. An 1824 Kentucky Supreme Court opinion referred to the prohibition on double jeopardy as a, quote, wise rule, so favorable and necessary to the liberty of the citizen, end quote, provides the citation. An 1833 decision by the New Jersey Supreme Court observed that, quote, this great principle forms one of the strong bulwarks of liberty, end quote, and provides the case law. Continuing, and in 1834, Justice Joseph Story called the Double Jeopardy Clause a, quote, constitutional recognition, end quote, of that, quote, fundamental rule of the common law, end quote, which has been recognized by elementary writers and courts of justice from a very early period down to the present times, end quote, provides the case law. Okay. All right, continuing. Just going to read this part in parentheses, listing the Double Jeopardy Clause as a provision enacted to, quote, secure the great palladium of liberty, the trial by jury in criminal cases from all possibility of abuse, end quote. In modern times, the Supreme Court has recognized the fundamental import of the Double Jeopardy Clause by expanding its scope. Notwithstanding the text of the Fifth Amendment, double jeopardy protection extends to all crimes, capital or otherwise, provides a citation, and the existence of an acquittal is a question of federal, not state, law, with a constitutional floor that prevents the states from impeding a defendant's double jeopardy rights, provides the case law. Double jeopardy also attaches when a jury is impaneled and sworn in, not when a verdict has been given, provides a case law. Okay. And guys, that's kind of like an FU to Beverly Cannoni. I'm not saying the ACLUM is saying FU to Beverly Cannoni. I'm saying FU to Beverly Cannoni, because right here, jeopardy also attaches when a jury is impaneled and sworn in, not when a verdict has been given. So you see, they're saying that Judge Beverly Cannoni and the prosecution swore up and down that the verdict is only a verdict if it's announced in open court. But here's the ACLUM providing case law saying that actually jeopardy also attaches when a jury is impaneled and sworn in that the moment the jury were sworn in, the moment the jury began their job the first day of trial, double jeopardy already applied before a verdict had ever even been reached. That actually, I'm just saying, guys, it's brilliant. It's wonderful. And it's almost like they're saying Judge Bev's legal arguments were non-legal arguments. Because again, to her, there were no verdicts because they weren't announced in open court. But to the ACLUM, that's not the argument here. The argument here is that the jury and the double jeopardy clause applies not when a verdict has been given, but when the jury is sworn in. Provides the case law. Continuing to read. Finally, as relevant to this case, the double jeopardy clause can bar retrial even when the first trial ends in a mistrial, in parentheses, with no acquittal or conviction, end quote. Amazing. I'm going to read that again. Finally, as relevant to this case, the double jeopardy clause can bar retrial even when the first trial ends in a mistrial. And that is not an argument that Judge Bev Cannoni made at all. She was basically saying she can't do anything, it's out of her hands because there was no verdict. And the ACLUM is saying, no, the double jeopardy clause applies even in a mistrial. Even in a mistrial. Continuing to read. For, quote, even if the first trial is not completed, a second prosecution may be grossly unfair, end quote, and burdensome to the defendant, provides a case law. Moreover, the defendant has a, quote, valued right to have his trial completed by a particular tribunal, end quote, provides a case law, such that only the showing of, quote, manifest necessary, end quote, will allow a trial court to declare a mistrial without barring a retrial on double jeopardy grounds. I love it, guys. They are questioning the validity of the mistrial. And that's what we needed. We needed this. We needed somebody else to come in and question the validity of the mistrial. It was not valid. Continuing to read. The decision to declare a mistrial without a defendant's consent is only justified by a, quote, high degree, end quote, of necessity, provides the case law, and requires, quote, a scrupulous exercise of judicial discretion, end quote, United States versus Jorn. Continuing, in Massachusetts, where there is no specific constitutional protection against double jeopardy, but where the common law protection thereof may be, quote, greater than either the state or the federal constitution requires, provides the case law, the declaration of a mistrial requires the trial court to both, one, provide defendant's counsel with a, quote, full opportunity to be heard, end quote, and two, carefully considered alternatives to a mistrial, provides the case law. Okay, so again, so far they're saying the declaration of a mistrial requires two things: provide the defendant's counsel with a full opportunity to be heard, and two, to carefully consider alternatives to a mistrial. Continuing, together the above sources sing a simple but powerful melody regarding the importance of the right against double jeopardy in criminal proceedings, which is, quote, deeply ingrained, end quote, in, quote, the Anglo-American system of jurisprudence, end quote. Citation. And bolstered by recent precedent. Accordingly, when the government asserts the power to retry a defendant who has already gone through the burdens of one full trial, as is the case here, courts must safeguard the defendant's fundamental rights by carefully scrutinizing that assertion in light of all available information. Yes. Again, they are stressing that this should all have been done carefully. It should have been done cautiously. Neither of those things happened. Judge Beverly Cannoni was not careful and she was not cautious. If anything, she was suspicious as fuck. Continuing. Number 2, trial courts regularly poll juries both after a verdict is announced and before a mistrial is declared. In her motion to dismiss, appellant asked for a post-verdict evidentiary hearing to determine whether the jury had agreed to acquit her on counts 1 and 3. Provides a citation. The Commonwealth opposed this request as, quote, improper, and citation, and the trial court rejected it as, quote, prohibited. They sure did. Improper, prohibited. But the propriety and sometimes necessity of inquiring about the outcome of a jury's deliberations is confirmed by the fact that trial courts regularly poll juries on verdict-related issues. Massachusetts courts frequently poll juries to determine whether the announced verdict was correct. Consistent with Massachusetts procedural rules, courts in this state and others also poll juries to determine whether deadlock exists or if future deliberation would be useful. And guys, Judge Beverly Cannoni knows this. She knows all of this. She just didn't want to do her job. She didn't want to do her job because I suspect, as I have said, that she is in cahoots with the Norfolk DA's office. Continuing. Massachusetts Guide to Evidence Section 606B and Rules of Criminal Procedure 27D both allow the court to poll juries after a verdict has been returned. Granted, quote, it is within the trial judge's discretion whether to poll the jury, end quote, provides the case law. But, quote, there are times when a judge should use the discretion accorded by Massachusetts law to poll a jury after the verdict is returned, end quote, provides the case law. For example, in Commonwealth versus Nettis case law, the trial court properly conducted a poll of the jury when one juror indicated her disapproval of the announced verdict. As with the evidentiary hearings discussed above, the court's polling of juror votes does not impermissibly intrude into the jury's deliberative process. Oh, guys, this is okay. Yes. All right. Reading it again, because I have made that exact same effing argument. Okay. As with the evidentiary hearings discussed above, the court's polling of juror votes does not impermissibly intrude into the jury's deliberative process. And what was the prosecution and Judge Beverly Cannoni? What were they doing? What were they doing? They were pretending that the defense team was asking for one thing when the defense team was actually asking for something much simpler, right? The defense team was saying, hey, can we please ask the jury? Can we please bring the jury back in to ask them if they were actually unanimous on counts 1 and 3 that Karen Reed was not guilty? And that was a simple request. It was simply, can we please
poll the jury? Can we ask them, were there verdicts on counts 1 and 3? And what was the prosecution's response? What was Judge Beverly Cannoni's response? What was their response? We can't go into the jury deliberations. And here is the ACLUM saying that, in fact, it does not impermissibly intrude into the jury's deliberative process. Just, it's really validating, you know? And again, guys, she knows this. The prosecution knows this. Judge Beverly Cannoni knows this. I want to know if the Supreme Judicial Court is going to do the right thing. Okay, Judge Bev can play stupid. The prosecution can play stupid. But in my opinion, the Judicial Court has no room to play stupid here. They are the Supreme Judicial Court. They cannot possibly play stupid here. The world is watching. Continuing to read. Federal trial courts have also polled juries to determine whether they are truly deadlocked ahead of a mistrial declaration. In United States versus Barbioni, the jury deliberated for 10 hours but could not reach a verdict. Before declaring a mistrial, the district court polled each juror individually and, quote, with great care, end quote. Yeah, it would have been so nice. It would have been so nice if we witnessed and observed great care from Judge Beverly Cannoni. But, you know, great care and Judge Beverly Cannoni in the same sentence, it's too much to ask for, right? It's not in this reality. It ain't never gonna happen. Continuing to read. All stated that the jury was deadlocked and not likely to reach a verdict. On appeal, the First Circuit found that these actions supported manifest necessity for a retrial. Many other federal courts have also polled individual jurors to ask whether a deadlock exists before declaring a mistrial. Really good. It's a really good argument. They're saying that in that case, the jury were polled and they could not reach a unanimous verdict. Therefore, it was grounds for a retrial because they were genuinely deadlocked. The ACLUM is arguing that the jury in the Karen Reed case was not genuinely deadlocked. They were deadlocked on count 2, not count 1 and 3. Continuing to read. State trial courts have likewise polled jurors ahead of mistrial declaration in order to determine whether manifest necessity exists. In State versus Jandrew, the jury sent 3 notes that indicated potential deadlock. The trial court individually polled the jurors after each note to determine whether deadlock truly existed. On appeal, the Maine Supreme Court characterized the effort as, quote, thorough and appropriate, end quote, to determining whether a mistrial was manifestly necessary. Other state courts have exercised similar care to thoroughly assess whether a mistrial was necessary. Provides case law. Multiple case law. Beautiful. Continuing. This kind of pre-mistrial polling is not only permitted under Massachusetts law, it is encouraged. Under Rule of Criminal Procedure 27B, a court intending to declare a mistrial may ask that a jury, quote, return verdicts on those charges upon which the jury can agree, end quote. The reporter's note to Rule 27B states even more definitively that, quote, the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. And if you've been following me up until this point, you know I have beat that dead horse. I have beat it to death and then some. Brought it back to life and beat it again to death. Rule 27B was completely and utterly ignored, even though, because there were multiple counts, because there were multiple counts against Karen Reed, Judge Beverly Cannoni was supposed to follow it. She was supposed to follow it. And there were multiple arguments going on at the time. Well, it just gives her permission. It only gives her permission, like it's optional. No, it was not optional. It definitively stated in the rule that she had permission to declare a mistrial. However, she was supposed to first require, as in mandate, that the jury give her verdicts that they did agree on. And I drove this home. I drove that rule home. Judge Beverly Cannoni played stupid. She played dumb. Again, it was as if she already knew the verdicts, people. It was as if Judge Beverly Cannoni already knew the verdicts. And that's why her declaration of a mistrial was hasty. Even the ACLUM considers it hasty. Continuing to read, thus Massachusetts law expressly enables judges to poll juries ahead of a mistrial to determine whether a full or partial mistrial should be declared. That fact supports appellant's requested evidentiary hearing because such a hearing would achieve the same goal as polling. For the court and the parties to receive an accurate assessment of the jurors' conclusions without probing, quote, the subjective mental processes of jurors, such as the reason for their decisions, end quote, and provides a case law. It's really well done, guys. These lawyers, I've said it before, defense lawyers looking out for civil rights and civil liberties, they are the true heroes of our time. They are our heroes in that they are our only defense against oppressive powers. And it is so clear that Norfolk County is being run by oppressive people. And Judge Beverly Cannoni herself is in that group. Number 3, trial courts also routinely hold post-verdict evidentiary hearings to address irregularities. I can't say that word. Yeah, irregularities. I never use that word. In jury proceedings affecting constitutional rights. Continuing, the propriety of appellant's requested post-verdict evidentiary hearing is also supported by Massachusetts precedent, which allows for post-verdict evidentiary hearings that inquire into irregularities with jury proceedings that affect constitutional rights, including double jeopardy. The most prominent example of such post-verdict hearings implicates the Sixth Amendment right to an impartial jury. And it says, see U.S. Constitution Amendment, quote, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, end quote. Trial courts may conduct a post-verdict evidentiary hearing where evidence suggests that, quote, extrinsic influence may have had an impact upon the jury's impartiality, provides the case law. I apologize for the ads. Continuing, the refusal to do so can itself constitute, quote, reversible error, end quote. Wow, that's powerful. The refusal to do so can itself constitute, quote, reversible error. And where the case, quote, courts should exercise discretion in favor of conducting a judicial inquiry. Okay. All right, I want to read this again. Okay, the refusal to do so can itself constitute, quote, reversible error. And where the case is close, courts should exercise discretion in favor of conducting a judicial inquiry. Thus, trial courts regularly hold evidentiary hearings to determine whether extraneous influence had an impact on the jury's impartiality, provides the case law. And the refusal to hold a hearing to consider extraneous influence has frequently resulted in reversal on appeal. And these are arguments that the Karen Reed defense team didn't even make. That's the other benefit of having a third party come in, another group of lawyers come in and look at this case and look at all the court documents and all the filings and come in with their experience and with their research. They're providing more power to the Karen Reed defense team. Through their experience, through their knowledge that maybe the Karen Reed defense team doesn't have. It's just, this is all really good news, guys. And I hope you know this is a really big deal. Okay, continuing. Evidentiary hearings have also been held to determine whether a jury's verdict was unanimous, as required by Massachusetts Rule of Criminal Procedure 27A, and as relevant for purposes of the Double Jeopardy Clause, since a prior acquittal or conviction bars a retrial for the same offense. In Commonwealth v. Brown, the jury foreman claimed that the verdict was erroneous, and the trial court held an evidentiary hearing wherein the jury corrected its verdict. Yeah. See, they're providing examples of when that these things actually happen. Evidentiary hearings pertaining to jury verdicts actually happen. And it makes me so pissed off at the Massachusetts dean of that law school, Michael Coyne. It makes me so pissed off at him as a lawyer in Massachusetts for all the bullshit he said on Canton Confidential and NBC 10 Boston, wherever the hell he was. They really need to stop using him because he's provided so much misinformation. He made it seem like this shit never happens. We can't go into jury deliberations, which wasn't even the argument. But he made it seem like asking for a post-trial evidentiary hearing was something we just don't do. We would have to create new case law. We can't create new case law. I don't see the Supreme Judicial Court going for it. That's all Michael Coyne, a dean of a Massachusetts law school. Okay? And he's being used on mainstream media, on Canton Confidential. Like as if he knows what he's talking about, when he clearly doesn't know what the hell he's talking about. Look at all these examples in which an evidentiary hearing is being held in the state of Massachusetts in order to determine what the verdicts were. Oh, it makes me livid. It's like validating, and I'm happy for Karen Reed. This is really good news, but it's also angering because there are multiple people, including Judge Bev herself, who just lied to us. They all fucking lied to us, including Michael Coyne, whoever he is. Okay. All right. I gotta find where I was. The jury foreman claimed that the verdict was erroneous, and the trial court had held an evidentiary hearing wherein the jury corrected its verdict. On appeal, this court found, quote, no impropriety, end quote, in the trial court's actions. Case law, a juror told the trial court that she had not agreed with the verdict. The court interviewed the, quote, remaining deliberating jurors, the court officers, the clerk of the court, and any personnel who had knowledge about the rendition of the verdict in this case, end quote. Before declining to disturb the verdict, in the wake of this investigation, this court affirmed the lower court's denial of the defendant's motion for a new trial. Additional cases from this and other jurisdictions affirm the ability of courts to conduct such proceedings and take corrective action regarding jury verdicts, provides the case law. To be clear, such inquiries need not reach the content of the jurors' deliberations or the particular reasons for their decision. Yes, like I knew that. Any other lawyer looking at this knew that. But Michael Coyne and Judge Beverly Cannoni and Adam Lally and Michael Morrissey, They all want to pretend that by asking for an evidentiary hearing, we would be going into jury deliberations. And it's just not the truth. I knew it wasn't the fucking truth. It was an obfuscation of the argument that the defense team was trying to make. Oh my gosh, God forbid anybody in Norfolk County wants to poll a jury. Continuing to read. There is no obstacle to a trial court taking evidence as to the outcome of the jury's deliberations, given that reporting such information is fundamentally the purpose of the jury. Through such an inquiry, the court can determine the jury's decision, which necessarily bears on whether the robust protections of the double jeopardy clause will apply. They're making it sound so practical. You see, they're making it sound like no shit. Like, it's so simple. It's so simple. Just poll the jury. We do it all the time in Massachusetts. What's your problem? Just do it. It's just really good stuff, guys. All right. Number 4, the trial court should be compelled to conduct an evidentiary hearing, given reports from jurors that the jury agreed appellant was not guilty on counts 1 and 3, such that the court did not have the manifest necessity to declare a full mistrial. In this case, after receiving a third note from the jury indicating difficulty reaching a completely unanimous verdict, the trial court declared a mistrial on all counts and set the stage for a full retrial. But as appellant's brief cogently describes, her attorneys soon received multiple reports from jurors, in some cases via intermediaries, that the jury had unanimously agreed to acquit on counts 1 and 3. Provides a citation. Juror A stated that the jury, quote, unanimously, end quote, agreed to acquit appellant on counts 1 and 3. Juror B believed that, quote, every member of the jury, if asked, would confirm, end quote, that the jury agreed to acquit appellant on counts 1 and 3. Juror D said that, quote, every one of us will agree and acknowledge, end quote, that the jury found appellant not guilty of counts 1 and 3. And Juror E confirmed that, quote, the jury was unanimous on counts 1 and 3. The Commonwealth also received communications from individual jurors about the jury's agreement on the first and third counts. Provides a citation. It is thus unsurprising that the trial court accepted the jurors' statements about this agreement as true and accurate. So the ACLUM just went through all the jurors who came forward and provided their verbatim statements, saying that Karen Reed was found not guilty on counts 1 and 3, unanimously. And the Judge Beverly Cannoni herself, considered their statements true and accurate. Continuing. Given such overwhelming evidence of the jury's agreement on counts 1 and 3, a post-verdict evidentiary hearing must be ordered to determine whether the jury decided to acquit appellant on any counts, such that the trial court did not have manifest necessity to declare a full mistrial. Such a hearing is warranted to assure the sanctity of appellant's right to be free from double jeopardy, a fundamental right, wide in scope, that is, quote, deeply ingrained, end quote, in our legal system. In the area of manifest necessity and mistrial, this court enforces that fundamental right by requiring the, quote, careful consideration, end quote, of, quote, alternatives to a mistrial, end quote. Provides case law. And I'll read what's in parentheses. A mistrial declaration calls for the, quote, scrupulous exercise of the judicial discretion, end quote. Given Rule 27B and the nationwide practice of polling juries before mistrials are declared, Part 2, the trial court could have avoided the instant controversy of polling jurors individually before declaring a mistrial. Unfortunately, it did not. See, okay, I'm pulling away, guys. That, as I have said in previous videos, if Judge Beverly Cannoni just took some accountability if she just took some accountability here, and if she was humble, if she was a humble human being, she would have said, OMG, there were verdicts on counts 1 and 3. I consider them true and accurate. I'm gonna host an evidentiary hearing. I'm just gonna put it together because I fucked up. But she didn't do that. She did not do that. She did not correct her actions. She in fact blamed. She in fact blame shifted. She blame shifted and accused the defense of not doing their job. She accused the defense of fucking around. Right? She brought up how the defense wanted to talk to the press. You know? Like, Judge Bev brought up irrelevant shit in her court filing when she could have just taken a little bit accountability, a little bit responsibility for what happened that day when she, the judge, the court, declared a mistrial without citing any rules to declare a mistrial, without having any manifest necessity to declare a mistrial, without polling the jury, without asking the defense or the prosecution what their feelings were before she declared a mistrial. On multiple examples here, Judge Beverly Cannoni is doing whatever the hell she wants to do. And when she is confronted that she did whatever the hell she wanted to do, she blames the defense team. She blames them when they didn't actually do anything wrong. At no point is Judge Bev Cannoni in her filings taking any responsibility for screwing over that jury and for screwing over Karen Reed. And now the ACLUM has to come in and tell her. And they're not telling her, but it's like, think of it as if she's reading this. They have to come in and say, you could have just done this, Judge. You could have just done this. It would have been so simple if you just did this. And because you didn't do this, you owe it to Karen Reed, to her civil rights, to correct your error. I've been saying this, and now the ACLUM is saying this. She had multiple opportunities to make this right, and she refused. And I really hope that she's embarrassed. I really hope so. You know, I doubt it. I feel like she's probably a sociopath and she doesn't want to, she'll never take responsibility. She's not humble enough to see the evil in her ways. But I really fucking hope she's embarrassed. She should be. And as I said, she should not be a judge in any case. She should not be overseeing any case in Massachusetts. But you best believe she is. You best believe plenty of other people are damned because of Judge Beverly Cannoni, because she's still a judge to this day. Continuing to read. Unfortunately, it did not, nor does the record reflect that the parties were given an opportunity to request or express their views on whether polling was appropriate. In any event, after the court declared a mistrial on all counts, it promptly received reports that its declaration of a mistrial was premised on an apparent mistake or misunderstanding concerning the jurors' conclusions, i.e., that they were deadlocked on only one count and had actually agreed to acquit appellant on others. At that point, the court not only could have, but should have, held an evidentiary hearing to determine whether, in fact, there was manifest necessity for a full mistrial. The court's refusal to do so is irreversible error. Sorry, let me read that again. The court's refusal to do so is reversible error. Okay. Yeah, it's yeah, they are saying that her mistake, her error is fixable. It is reversible. And it is up to the Supreme Judicial Court. An evidentiary hearing was and remains necessary because a lack of manifest necessity would mean that retrial on counts 1 and 3, or 1 and or 3 violates appellant's rights under the double jeopardy clause, provides the case law. Because that clause protects against the burden of enduring multiple trials, not merely the possibility of a conviction upon retrial, a violation of appellant's double jeopardy rights cannot be remedied after a second trial, whether or not she is ever convicted. And I'm going to read this in parentheses. Retrial subjects the defendant to, quote, embarrassment, expense, and ordeal, end quote, and compels her to, quote, live in a continuing state of anxiety and insecurity, end quote, provides the case law. In parentheses, the, quote, the prohibition is not against being twice punished, but against being twice put in jeopardy, end quote. Yeah. Because there's a difference between jeopardy and punishment. Jeopardy meaning you're at risk. And because Karen Reed was found not guilty on counts 1 and 3, she should not be retried on those counts. Because being retried on those counts puts Karen Reed at risk. It puts her in jeopardy. Continuing to read. Put another way, if the trial court lacked manifest necessity for a mistrial on counts 1 and or 3, then appellant's double jeopardy rights will be irredeemably violated, even if she is someday acquitted of those charges at a subsequent trial. Thus, a, quote, wait and see, end quote, approach would potentially permit an irreversible violation of the Constitution, and an evidentiary hearing is necessary now. Powerful, guys. Powerfully written. And is that not Judge Beverly Cannoni's energy? Is that not Judge Bev Cannoni's approach? Wait and see. Instead of being careful and cautious, instead of being proactive and humble enough to see her own fuck up. She doesn't care. She doesn't, again, she should not be a judge. I wish the ACLU would I don't know, just find a way to disbar Judge Bev. I really wish they would. I wish they would look into her corruption. It's like, why is she a superior court judge? Why is Judge Beverly Cannoni a superior court judge? She clearly did not earn that position. She's so corrupt, and it's so blatant, and it's not only that the defense team called her on it, but now the ACLUM. Again, even though this filing is directed toward the Supreme Court, it's reflecting on Judge Beverly Cannoni's actions, which led us all here. Continuing, the trial court denied appellant's request for a hearing because it concluded that such a proceeding would, quote, impermissibly intrude into the, quote, the substance of the jury's deliberations, end quote. In justifying that ruling, the court said that a hearing would, quote, necessarily require the court to understand, end quote, any supposed tension between the jury's notes to the court and their agreement to acquit the appellant on 2 counts. But that is not so. That is not so, guys. Exactly. It's just not the truth. Continuing, the trial court is well situated to set appropriate limits on any questioning, and it may only need to ask each juror whether the jury reached unanimous verdicts on counts 1 and 2. Exactly. Oh, God. I'm going to read it again. The trial court is well situated to set appropriate limits on any questioning. Exactly. Exactly. Michael Coyne, Judge Beverly Cannoni. Exactly. It's not like, You bring the jury back in and, oh, it's going to be mayhem. Oh, no, the jury's back in my chambers. Oh, it's mayhem. No, it's your fucking courtroom. You control your courtroom and you control the questioning, just like you did during trial. Remember? You controlled the fucking lighting in the trial. You controlled whatever was on display for the jury, right? You can control the lighting in your courtroom, but you can't control the questioning for the jury in an evidentiary hearing. Give me a fucking break. And here is the ACLUM calling her on it. You as the judge have the power. You have the power and you're not using it. You're making excuses. All right. I am sorry if I'm yelling into your ears, guys. Holy crap. All right. As cases like Span make clear, questioning to confirm or understand what the jury decided does not intrude into the deliberative process. Thank you. Amen. Validation. Continuing, in response, the Commonwealth may claim that because post-trial reports from jurors A, B, D, and E were not in front of the trial court when it declared a mistrial, a partial verdict was not a reasonable alternative at the time of the court's declaration. But that argument fails for two reasons. Let's go. How does it fail? Come on. All right. First, as appellant observes, the jury's communications with the trial court are susceptible to the interpretation that the only deadlock was related to the lesser included offenses of counts 2. So the trial court had reason to believe that a poll aimed to return a partial verdict was a meaningful alternative to a full mistrial, especially given the existence of Rule 27B. Boom. Boom. Awesome. Okay, next one. Second, cases like Diaz and Brown demonstrate that post-trial verdict evidence can support a post-verdict evidentiary hearing into the content of the jury's agreements, even if the evidence was not known to the court ex ante. Thus, the fact that evidence suggesting the jury reached a partial verdict arrived after trial does not preclude an evidentiary hearing. Yeah, guys, okay, they're saying that either way, her actions before declaring a mistrial were wrong. She was incorrect, especially because she didn't follow Rule 27B, and that even post-trial, she has the opportunity to again schedule an evidentiary hearing, and her reasoning for not scheduling an evidentiary hearing are insufficient. She is wrong both ways. Okay, continuing. The timing also supports the use of evidentiary hearing. As memorialized in attorney affidavits, jurors began raising concerns about the mistrial the day after that declaration was made, and others quickly followed suit. They sure did. Continuing. So there is robust, uniform, and contemporaneous evidence of the jury. Okay, gotta read it. Of what the jury agreed to. And contemporaneous meaning it's happening right now. There is contemporaneous evidence post-trial. That evidence was accumulated contemporaneously. It was handed to the defense team. It was handed to the prosecution. The jury did their due diligence. They reached out to both sides. And Judge Beverly Cannoni herself considered their statements true and accurate. But she did nothing with it. And it's not like, there's so much I could say, guys. But it's like, I don't have to say much because the ACLU, is doing a fantastic job. They are doing a fantastic job. And again, they are providing arguments that the defense team did not even provide, which again makes it all the more powerful, all the more compelling. All right, continuing. Supported by that evidence, appellant requested an evidentiary hearing within 1 week of the mistrial. Beyond that, the specific nature of this mistrial context lessens the risk of externally influenced post-trial changes. This is not a situation, This is not a situation where a court would be likely to find an agreement to acquit based on one's jurors changing view or post-trial misgivings, both because a significant portion of the jury has already come forward to evidence their agreement, and also because all of the jurors apparently remain available to testify. Okay, continuing. Almost 400 years ago, the Massachusetts colony enacted the first formal prohibitions against double jeopardy on American soil. In accordance with this tradition, the court should require an evidentiary hearing to ensure that appellant's double jeopardy rights are not violated by a second trial on counts for which the jury already agreed to acquit her and for which the trial court did not have manifest necessity to declare a mistrial. Such a remedy is necessary to maintain the double jeopardy clause as that, quote, strong bulwark of liberty, end quote, citation, which stands against the, quote, the devastating and one-sided nature of the jeopardy, end quote, that confronts criminal defendants facing retrial, provides case law. Conclusion. All right, guys, this is the end. Conclusion. For the foregoing reasons, this court should vacate the decision of the trial court denying appellant's motion to dismiss and remand for the trial court to conduct an evidentiary hearing if the charges are not otherwise disposed. Dated October 16, 2024. And it lists the attorneys and their email addresses. Wonderful. So just to summarize what the ACLUM is asking in their conclusion, they are asking the Supreme Judicial Court, this court, the Supreme Court, to vacate Judge Beverly Cannoni's decision, which again, she denied Karen Reed's motion to dismiss. And when a court vacates a decision, they are, it's not like it never happened, but they're undoing it. So to vacate something is to undo it. And then they are also asking the trial court to remand and conduct an evidentiary hearing if the charges are not otherwise disposed. So it's like, so they're saying like, they're requesting that the Supreme Court, the trial court, not the Supreme Court, they're asking the Supreme Court to order that the trial court conduct an evidentiary hearing. They're asking the Supreme Court to make it that the Superior Court, maybe not necessarily Judge Beverly Cannoni, I don't know if this is still going to be her case, but some judge in the Superior Court conduct an evidentiary hearing if the charges are not disposed before then. And again, that's within Judge Beverly Cannoni's power. And I said this in previous videos. She has the power to dismiss the charges altogether if she wants to. She has the power to do whatever she wants, and she knows it, and she displayed that during trial. Over and over again, she did whatever she wanted to do, up to and including the mistrial, her declaration of a mistrial. She declared that mistrial how she wanted to declare it. Not following any rule, not following any law, and not inquiring from either side what their feelings were before she declared a mistrial, and not polling the jury. And again, if she were humble, if she were a decent human being, she would look at her actions and say, I fucked up. I rushed it. But clearly she's like the Karen Reed haters. They don't want to do what's right. They just want to be right. Judge Beverly Cannoni has continued to demonstrate that she does not want to do what is right. She just wants to be right. She wants to pretend that she's right. And I don't know who made her a Superior Court judge, but whoever made her a Superior Court judge, Michael Morrissey, they are equally corrupt. It's clear. And it's like the ACLUM here is implying that in their last sentence, if the charges are not otherwise disposed. You know, like, because again, not only can Judge Beverly Cannoni, not only could she have dismissed counts 1 and 3 just from what the jurors said post-trial. She could have also said, and I don't think we need to retry her on count 2. That's within her power, and then it would have been up to the prosecution to appeal. I'm just saying, guys, she was at liberty to do multiple things here. But she is clearly on a bandwagon with the prosecution, just like the world witnessed during trial. And we all witnessed it post-trial. She would not budge. And now here's the ACLUM. Again, a completely independent group of lawyers, experienced lawyers, essentially making the same arguments that the defense team made and more. Judge Beverly Cannoni was wrong. And they're calling it an error. I get it. They got to be professional here. It was erroneous. It was just an error. It was a mistake. They are being good lawyers. I would not be a good lawyer because to me, it was not an error. It was a deliberate fuck up. A deliberate attempt to screw over Karen Reed's fate. And it's all the more clear reading legal arguments from a completely independent third party here, the ACLUM. It's all the more validating, all the more compelling. It's not just the defense team saying you were wrong, Judge Bev. It's also these guys saying the same thing. She was wrong. And some people might perceive it as a mistake or an error. I don't. I do not. I think she's in cahoots with the prosecution. She's in cahoots with Michael Morrissey. She doesn't have a humble bone in her body, Judge Beverly Cannoni. And I feel bad for anybody who has her as a judge right now. And I hope everybody who has her as a judge right now reaches out to the ACLUM. I really hope an investigation is done into Judge Beverly Cannoni's cases. She is not right. She is not okay. And anybody she is making decisions for, they are not okay either. They're not going to be okay. they need help. I will read the Commonwealth's brief that they filed yesterday. I will read it tomorrow in part 2. I am grateful, guys. I am so fucking grateful that the ACLUM came forward and provided this, but I am also like all the more angry because it's like we weren't wrong. Michael Coyne, Sue O'Connell, Michael Morrissey, Judge Beverly Cannoni. You know, how do any of you guys sleep at night? Thank you for watching.